Okay, so welcome everyone. We are so glad you're here. Good afternoon. Welcome to today's session hosted by the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics at Harvard Law School and the Center for Law, Brain, and Behavior at Massachusetts General Hospital. So in recent years, advances in neuroscience have deepened our understanding of how the brain develops well into the 20s and how these developmental realities intersect with our legal system's practices around criminal responsibility, sentencing, and resentencing. Today's discussion will start with an overview of the developmental neuroscience that is shaping court rulings, and we'll examine key state decisions and legislative reforms that respond to the science, from landmark rulings in cases like Washington v. Munchkey and Commonwealth v. Mattis, and legislative endeavors in Hawaii. And a special thank you to Dr. Kristen Carson. We gave a version of this talk in Washington, D.C., and thank you for your support. We are grateful to our speakers and panelists for bringing deep expertise from neuroscience, law, and lived experience, and we look forward to an engaged conversation on how evolving knowledge of the young adult brain can inform more equitable, evidence-based approaches in the court system. So for questions, Q&A will be at the end. Please put your questions in the Q&A. The chat will be turned off. So I'm going to do some brief introductions, and then we're going to launch into this talk. So my name is Stephanie Tabashneck. I am a forensic psychologist and attorney at the Center for Law, Brain, and Behavior at Mass General Hospital and Petrie-Flom at Harvard Law School. And I do evaluations of juveniles and emerging adults, mostly who committed homicide. I run the CLBB Neurolaw Library and train judges and attorneys on applied neuroscience. Andrew Charroux is here, and he is a senior research associate at CLBB, where he supports the CLBB Neurolaw Library and initiatives aligning the law with the science of addictions and adolescent brain development. We're also joined here by Nate Benjamin, who was released from prison in August 2025 after 30 years of incarceration beginning at age 20. He's currently a student at Tufts University in the Tufts Education and Reentry Network program, My Turn. He has many years of experience speaking with at-risk youth and training men to facilitate groups in gang prevention, violence reduction, and victim empathy. A survivor of severe trauma, he centers his life around healing. And so now we will launch in. Just give me one moment. Okay, so we're going to be covering a lot of ground. I'm going to speak relatively quickly, and so if you can just bear with me, and all of my slides will be available at the end. And Andrew, do you just mind spotlighting me? And Nate, if you want to turn off your video, that would be great. So we're going to start with adolescent and emerging adult brain development. Then we're going to review the key Supreme Court case law, state case law developments. Then we'll turn to Washington v. Munchkey, and Nate's going to speak about his lived experience, which will be, I think, very meaningful for all of us. So recently I saw this sign in DC, and it said shoppers under the age of 18 may not enter without an adult after 6 p.m. And I talked to the security guard because I'm friendly, I'm from the Midwest. And I asked her if she thought that that number should be 21. And I told her about some recent court decisions that had banned life without parole sentences for those who were under 21, because a lot of the neuroscience applies to that group along with people who are under 18. And she agreed. So I used ChatGPT to change the sign to 21. So just briefly, compared to adults, adolescents, our adolescents and late adolescents really share a lot of brain development, neurocircuitry, and the too long don't read is that their brains are different from adult brains. So we see changes in gray matter volume throughout the life cycle, changes in white matter development, cortical thinning, and we see changes in myelination and neural connection, so the way that different brain regions talk to each other. And what we know is that the teen brain and the emerging adult brain are really wired for stimulation and for high emotionality. So the limbic system, the striatum, for example, is overly developed, and this is the area of the brain that really guides emotions and feelings. And the prefrontal cortex, which guides judgment and reasoning, is less developed. And so what happens is that the brain sort of privileges emotions over reason. So adolescents and emerging adults are less likely than adults to think about the future consequences of their actions. Robert Kincherf, who's the executive director of CLBB, likes to give this really amazing example of how a teenager, an emerging adult, is probably equally likely to, spends about equal time on the decision of whether to commit an armed robbery as they do on whether they should have a Hot Pocket for dinner. One has lifelong consequences and the other is just probably bad for your body. Adolescents are less likely to plan beyond the short term. They're very focused on what's going on now. They're more likely to have difficulty resisting peer influence, and when they have peers who are around them, they tend to make worse decisions. And they're not great at considering both the risks and the rewards of a decision. So this is a brain scan just looking at the activation of reward centers in the brain when a friend is watching versus someone is just by themselves and they're 14 to 18 years old. And you'll see much greater activation in the brain when a peer is present. And what's interesting is that the peer doesn't even necessarily have to be present. They just have to, the teenagers has to be told that a peer is present. So if they say, oh yeah, someone else is watching you who's in your age range, then you'll see more activation in the brain in this area, which then leads to a riskier decision making. And this neuroscience, the 14 to 18-year-old age range, really applies to the 18 to 21-year-old age range as well. Now, we know that the adolescent brain and the emerging adult brain are more likely to encode threats. So when we look at studies, for example, and people are shown faces, so neutral faces, adolescents and emerging adults, those 18 to 21, really tend to view neutral facial expressions as more threatening. So I think for all of us forensic psychologists in the room or attorneys in the room who've worked on cases involving, those who are under 21, and they've, shot someone or stabbed someone and they said, I did it because I was scared or I thought there was a threat. And we, with our more mature adult brains, may not be able to really understand why that was, but there is a neuroscientific basis for that feeling. So when thinking about hot cognition and cold cognition, which are really important factors, what we know is that when the person is under a lot of stress, when there's a lot of emotionality, when there's a lot of immediacy and there's a lot of pressure in the moment, this is where those who are under 21 just make way worse decisions than those who are in their late 20s or 30s. Okay, so this is called a hot cognition context. And then a cold cognition context, this is a sort of calm environment where there's not a lot that is going on, and there's a lot of time to sort of think through what's going to happen next. This is where we see adolescents and late adolescents make pretty good decisions. So for example, the APA, the American Psychological Association, caught some slack because they said, well, we shouldn't be, executing kids or sentencing them to life without parole because they make bad decisions relative to adults and they have all these problems with their judgment. And then they also submitted an amicus brief that said, that teenagers were sufficiently capable to be able to make reproductive rights decisions. So on the one hand, this could be seen as like, okay, the APA is being overly political. But really this distinguishing factor here is that the decision whether to terminate a pregnancy doesn't happen in 1 second. It happens over time. There's time to deliberate. There's time to think about it. And in medical decisions, adolescents make pretty good decisions. So this is, in most crimes, I would say occur in a hot cognition context. So on average, we know that teenagers and emerging adults commit more violent crime. And you'll see this is the age crime curve that criminal offending peaks around age 18, 19, and then it goes down. And what we know is that even people who commit serious crimes, so for example, people who commit homicide or sexual assault in adolescence or late adolescence, they're likely to desist from criminal offending as they enter into their early to mid 20s. And not go on to commit further crimes. We know that that teenagers and emerging adults have more automobile crashes, more unintended pregnancies, they drown more often, there's more non-fatal self-inflicted injuries, they're more likely to experiment with drugs. We know that impulsivity declines with age, and really look at this drop off. So we have 22 to 25, and then look what happens around age 26. So for some of the neuroscience that I'm discussing, we're mostly talking about up until age 21, but I would say in a lot of areas, some of this neuroscience applies to those until around age 25 as well. We know that sensation seeking declines with age. So the adolescent and emerging adult brain actually has somewhat of a preference for risk, and especially those who are 16 and 17. their brain is just, it receives a lot of positive feedback. It really likes when there's a risky decision. So they'll choose risk over, like what I would choose, which is a quiet night at home with no risk. Okay. And they're also not very good at perceiving risk. So at the same time that their brain is seeking out risk, they're also not very good at perceiving, like, is this a good decision? Is this a bad decision? How could this impact me later on? And that development, continues until the mid-20s. So thinking about the future, for those of you who are parents who've tried to get your adolescent kiddo to do their homework and have talked about, well, this could affect you for the rest of your life. Not having access to, if you're not getting good grades, this could affect where you go to college, and have been met with a teenager who just doesn't care. Here's the neurobiological basis for that. It's really hard for teenagers to think about anything outside of the present. Older individuals are more willing to delay gratification. And even this idea of like spending more time on a harder problem. So for example, if you're deciding whether to buy, house A or house B, versus deciding, where to go for coffee in the morning, you're probably going to spend a lot more time on the harder problem, right? But especially for young kids, they're spending more time on the easier problem, and then you're not seeing like a huge gap between these two until the mid to late 20s. Okay. So being able to resist peer influence, I invite everyone in this room, in this Zoom room, to think about when you were a teenager, if there was anything that you did that a friend suggested, or maybe you suggested, that now you're like, oh, I would never do that. I would never do that now. So we know that peer presence, and not just peer pressure, peer presence, really impacts decision-making for adolescents and late adolescents. Okay. And this is a quote on criminal trajectories. We conclude that desistance processes are at work even among active offenders and predicted life course persisters, and that childhood prognosis accounts poorly for long-term trajectories of offending. So what this quote basically says is that most people who commit crimes when they're under the age of 21, 18, are unlikely to continue to commit crimes as they enter into adulthood. Okay, so this is a question that I think for those of you who have testified in court are often asked by judges, attorneys, prosecutors: when is the brain finished developing? And what's really challenging is this really depends on how you're measuring brain development. So are you looking at the prefrontal cortex? Are you looking at the amygdala? Are you looking at gray matter? Are you looking at cortical thickness? Are you looking at behavioral neuroscience? So are you looking at how people are sort of scoring on various tasks? And while we can say that we see some similarities, it's really difficult to say, like, I don't think we'll ever have an answer to when is the brain finished developing, because some regions will be developing for the duration of your life. Others sort of, peter out, like the prefrontal cortex at around age 25. And we simply don't have enough brain scans to be able to say, like, where, like, for example, a defendant sits in comparison to other people their age range. I think we'll eventually get to a point where that is possible, but right now, where an MRI I think is between $3,000 to $8,000, we're just not there yet. We do have the ABCD study, which I hope is still being studied or being funded, where we're looking at brain development more over the lifespan. So from a very young age, longitudinally into adulthood, and that will give us some comparison basis, which I think will be helpful. Okay, and judgment is the very last to develop, which will surprise, I think, no one. And just a quick note that the research that looks at brain development is really focused on a healthy population that has low trauma. So when you think about like who is able to go and participate in studies at a university and take time out of their day to take their kids there, it's people who are mostly wealthier, white, professors. So when we look at trauma has a profound impact on brain development. So, if you're working on a case with someone who has a history of trauma, their prefrontal cortex may not be sort of fully developed until they're, 30. So trauma can delay brain development and has impact on a number of different brain regions. Okay. And we see this not just for mental health and medical issues, but when we look at the life expectancy of those who've had more than have six or more adverse childhood experiences, so physical abuse, emotional abuse, sexual abuse, their life expectancy on average drops down to 60 years old. So this is a really profound difference. So what does all of this mean? This means that adolescence and late adolescence is really a time where this age group is seeking out a lot of arousal, risk. They're very sensitive to social feedback and their peers, and they're less likely to control impulses. They're less likely to sort of resist groupthink or what's going on with their peers. They don't tend to plan ahead. They're really driven by the thrill of rewards. And we have a neuroscientific basis to say these things. So some of you will say, well, as a parent or as a former reformed teen, I know all these things, but we also have neuroscience that really backs these claims up. Okay, so to summarize this, really having it's like having a Ferrari or Porsche engine with a smart car brake. Okay, so Ferrari or Porsche engine with smart car brakes. That's how this difference really materializes. Okay, and someone just asked if the slides will be available at the end of the presentation, and yes, they will be. We will be posting them and sending them out, or you can email me. Okay, so now I'm going to go over some of the Supreme Court case law. I'm going to briefly talk about this because I think most people here are already aware of this case law. And so we're going to just, move through this fairly quickly. So children are constitutionally different from adults in their levels of culpability. This is from Miller v. Alabama. JDB v. North Carolina, this was looking at whether someone is under interrogation or free to go or under arrest. In 2011, they expanded that test to also include consideration of age, which is that, and there are very few things that are added as additional considerations for interrogation, but age was added as one of them. Okay. And then next we have Roper v. Simmons, which banned execution of juveniles as a class. And there was references to developments in psychology and brain science and how the brain doesn't develop until late adolescence. And Graham v. Florida, which banned life without parole for non-homicide for juveniles. There was reference to scientific and sociological studies. We saw lack of maturity, impetuosity, ill-considered actions and decisions. And the quote, adolescents are overrepresented statistically in virtually every category of reckless behavior, which we talked about earlier in the presentation. And then we had Miller v. Alabama, which barred mandatory life without parole for juveniles for homicide. And there were references to developmental psychology, neuroscience, brains not being fully mature, and scientific studies. Then we got to Jones v. Mississippi in 2021, which basically, I think, essentially overturned Miller without saying that it was overturning Miller, and just said that instead of having to go through all these different Miller factors to determine if someone, had sort of youthful immaturity, Jones just said that there had to be like acknowledgement of youth as a mitigating factor. So as long as there was like some perfunctory acknowledgement that the person was under 18, that was seen as sufficient. And what I think is very notable in this opinion is that there was absolutely no science referenced. I thought that was fascinating. Okay, so after Miller, what happened is, in response to Miller, there were a number of Miller fix statutes to bring states into compliance with Miller. And so we're going to talk a little bit about those. Now, with Jones, Jones basically said that states were welcome to create their own sort of statutory scheme, and so it didn't prohibit that. And so what we saw is that a number of states started kind of changing how they were interpreting Miller. So I'm going to start briefly with. I'm going to start, I think, with Michigan. I'll start with Massachusetts, but we're going to be turning to Washington State in just a moment when Andrew reviews that case law. But so what happened in Massachusetts is first we had Diachenko, which basically said that sentencing kids to life without parole was a violation of our state constitution. And so, yeah, so constitutionally different from adults for purposes of sentencing. and they, decided to draw the line at 18, the Massachusetts Supreme Court. Now, after Dyachenko, several attorneys, some of you are on this call, they said, okay, well, the neuroscience, it really doesn't stop at 18. It applies to those who are 19, 20, 21, almost equally to those who are under 18, and began, petitioning the state Supreme Court to sort of reconsider drawing the line, banning LWOP at 18. Now, eventually, we had a case called Mattis, which, the Mattis judge followed Dyachenko, followed the fact that that essentially the state Supreme Court had declined several times to expand the prohibition on life without parole to 18 to 21-year-olds. But the Mass Supreme Court did something very interesting and sort of kicked the case back to one of the trial judges, and because there were two cases, and Judge Allman, who I got to present with last week, which was very exciting. He talked about Mattis. He had to sort of have this evidentiary hearing to take testimony on adolescent brain development and whether that research sort of applied to those who are 18 to 21 and a number of other factors. So in 2024, the Mass Supreme Court was the first court in the country to fully ban those under 21 from being sentenced to life without parole. So I think this was really a groundbreaking case. And this was, so in the quote is, when it comes to determining whether a punishment is constitutional under the 8th Amendment to the United States Constitution or Article 26 of the Massachusetts Declaration of Rights, youth matters. And then there were citations to, juveniles having the same core neuropsychological or neurological characteristics as emerging adults, that, 18 to 20-year-olds function similarly to those who are under 18, sort of evolving knowledge about brain development and more sophistication in our brain imaging. Okay. And then there was a lot of reliance on science and research on sensation seeking, looking at even things like oxytocin receptors, the reward centers of the brain, and how this age range, 18 to 21-year-olds, experience peer presence differently. Okay, so we were the first state in the country to ban LWOP specifically for 18 to 20-year-olds, and it's not just mandatory LWOP; it's LWOP. So other states, we have Rhode Island, which passed Mario's Law. This was the Youthful Offender Act, which allowed individuals who were sentenced for an offense before age 22 to be eligible to seek parole after 20 years. And then this got expanded to emerging adults age 22, regardless of their sentences, including LWOP in 2024, which was a groundbreaking ruling. And then we had the Michigan Supreme Court. So in People v. Parks, mandatory LWOP was banned for 18-year-olds in 2022. This was seen as unconstitutional under the Michigan Constitution and Michigan's own statute on cruel and unusual punishment. And then we had People v. Sarnecki and People v. Taylor. This was in 2025, which expand the ban on mandatory LWOP to 19 to 20-year-olds. And the court specifically said the scientific research relied on by the Parks Court applied equally to 19 and 20-year-old individuals. And I think from a neuroscience perspective, this is correct. Now, this was sort of out of left field, and I don't know if anyone's from Hawaii. I'd be so interested to hear from them. But in June 2025, the Hawaii legislature banned life without parole sentences for emerging adults age 18 to 21. This was the first state in the country to ban LWOP specifically for emerging adults by statute. And this was signed by the governor, and I believe it's now gone into effect, which is very interesting. And then, yes, so just briefly, I'm also going to talk about, Kentucky recently had a case that was appealed to the appeals court. And the question was whether it was unconstitutional under the Kentucky Constitution to execute people who are 18 to 21. The appeals court remanded it to the district or superior court because they said that the defendants lacked standing because they had not yet been sentenced to death. So that was one case. Other states like Florida, Tennessee, New Jersey have just flat out rejected arguments about expanding the ban on LWOP to 18 to 21-year-olds and have said, Florida specifically has said, we're not doing that unless the Supreme Court tells us to. So this is a quote by Justice Kennedy, Roe v. Simmons: "The qualities that distinguish juveniles from adults do not disappear when an individual turns 18. So I just want to speak briefly about recidivism data post-Miller before I kick this over to Andrew. So what have we seen in the people who've been released after serving life without parole and then getting re-sentenced under Miller? So very few people who've been released who committed crimes as juveniles, who committed homicide as juveniles, have gone on to commit any other further violent crimes. Generally, these people tend to do well. I will say that having done both Diachenko evaluations and Mattis evaluations in Massachusetts, so people under 18 who commit a homicide and people under 21 who commit a homicide, I've seen their sort of incarceration history and their post-release functioning has been nearly indistinguishable. So what tends to happen is they have a rough first few years in prison, and then they are sort of model inmates and go on to do pretty good things. Okay, so yeah, most were able to find stable housing, they reconnected with family, were employed, and very few people in California sentenced to life without parole who were released ever went back to prison. Okay. So just briefly, and Andrew, if you can put a link in the chat. So before I turn this over to Andrew, I just want to talk briefly about the CLBB Neuro Law Library. So this is a free resource. Our first module was on juvenile and emerging adult justice, and the focus was on really making this information accessible to attorneys, judges, prosecutors, so that they could better understand adolescent brain development and come to better decisions more aligned with science. So where we also just I think last week, released an addictions module, which is up and running, which talks about sort of the criminalization of addiction and addiction as a brain disease. So we have over 800 scholarly articles, 500 plus amicus briefs, many cases. We have an AI-mediated comprehension slider that goes down to the 6th grade reading level. So if you want to understand a really technical neuroscience article, you can just use the comprehension slider and get a quick takeaway. I often use this because I'm busy and I just want to get to the heart of the article. And then there's a lot of different educational videos and things that may be helpful in terms of thinking about emerging adults. Lastly, we have 3 expert affidavits, which you can use for any of your cases. There's one from me, from Dr. Robert Kincherf, and Dr. Kristen Carson. And if you email us, we can sign those. And they're all about adolescent brain development. So I want to thank you for your attention. I'm going to turn this over to Andrew so he can talk to us about Commonwealth v. Munchke and what is going on in Washington State.
Thank you very much, Dr. Tabashneck. I'm going to be focusing on cases in the state of Washington. I hope everyone can see my screen. Please message if that's an issue. Washington is a really important case to look at as a case study because it not only shows the rapid changes in the law that can happen in light of recent neuroscience, but also I think illuminates a lot of the challenges and pitfalls that come up with applying brain science to criminal law. So we're going to start off by talking about the case of State of Washington v. Odell. This is a case in 2015 that revolved around Sean Thompson Odell, who just 10 days after turning 18 was convicted of second-degree rape and put in prison for, or given a prison sentence of 95 months. If this case had happened just 11 days prior to his 18th birthday, he would have had a prison sentence in a juvenile facility for between 15 and 36 months only, or weeks, sorry, only. And it shows, the drastic difference that happens right above the line of 18. Interestingly here, the trial court considered bringing up the fact that he was just over 18, but the judges in that case felt that they were bound by Washington state law to not bring up age as a mitigating factor because he was just over 18. And so the question that came before the Supreme Court of Washington here then was the sentencing judge correct when refusing to consider the relative youth as a mitigating factor. And so this case is really important because it showed that within the Supreme Court of Washington, there was this willingness to reevaluate their past decisions in light of both the changing law around juveniles, but also around the changing science for young adults. And so they noted that at the time of these rulings, they did not have the benefit of the studies relied on in Miller, Roper, and Graham. But they also go one step beyond this and say that even after turning 18, if you look at advances in scientific literature, the brain is still developing. And so they note that youthfulness remains a valid sentencing consideration even after the age of 18. And so we fast forward a couple of years, that takes us to Munchke, in re Munchke, which relies on this past case to consider the role of neuroscience in changing the way we treat people right above the age of 18. And so the question here was whether the constitutional requirement established at the Supreme Court level for that ban mandatory life without parole for people under the age of 18 also prohibits mandatory life without parole for people between the ages of 18 and 20. So 18, 19, and 20-year-olds. And if you look at the actual ruling here, the brain science, or just the thinking about how the brain works, is really central to the logic. Brain as a word comes up nearly 24 times within the opinion. You see neuroscience and neurological referenced 13 times. And because of this, the court recognizes that there's no neurological bright line between the ages of 17 or 18. In other words, right when you turn 18, it's not that the brain suddenly changes, it's that this is a line that, we've created as a society. And they also reference, because the two individuals in this case were 19 and 20, that this holds true even up to ages of 19 and 20. The thing is, in the actual argument, they say that the state argues that even if it's true that there's no bright line cutoff at 18 in terms of brain development, they say that the Supreme Court in Miller recognized that the line at 18 was not because of neuroscience. In fact, in Miller, they recognized that some people could be, less mature than a standard person above the age of 18, yet still this line at 18 must be drawn somewhere, and 18 is where we draw it. And this is not a sort of outlandish argument. You actually see this pretty prominently in other precedent-setting arguments. So in People v. Harris in the Supreme Court of Illinois, you see that this is an argument that the Supreme Court of that state adopts. And interestingly here, the Supreme Court of Washington does not see that as an important kind of counter argument to this suggestion. There's also this aspect of the G to I problem that the state puts forward. And so the G to I problem, it means the general to individual problem, and it's something you see when people discuss challenges bringing neuroscientific studies into law. And what it basically says is that if you look at neuroscientific studies that say something about, let's say, 20-year-olds versus 17-year-olds, the way they come to those understandings is by studying groups. So the information you have on a 20-year-old comes from an average of a group. They say this is a problem when bringing it to the law because what the law cares about is individuals, right? So even if you know something about a general group, it's not specific enough to actually inform how the court should rule on a specific case. Interestingly, though, if you look at the ruling in Munchke, you see that this kind of figures into the opposite argument, where they say, okay, well, if we recognize that there's variability among a group, that's even more reason for us to ban mandatory life without parole, because we need individualized sentences to be able to consider what that individual looks like compared to a group, right? So because of these arguments, the Supreme Court of Washington ends up ultimately saying that 18-year-olds share the same developing brains as those under 18, and that this holds above that line as well. So they say, thus, we hold that these 19 and 20-year-old petitioners must qualify for some of the same constitutional protections as well. I think what's pretty interesting, and I won't go too into this right now, we can maybe discuss it more in the Q&A, is that they rely on Roper as a sort of framing of the general differences between juveniles and adults, and they point to juveniles' lack of maturity, vulnerability to negative influences, and transitory and developing character. These are all things that the Roper court says are relevant differences that make juveniles not in the group of the worst offenders. But what's really notable to me here is that in the Munchke court, they rely, at least in terms of what they name, neurological science that says that there's no distinction between these two groups. Whereas if you look at the actual kind of core things directly referenced when Roper makes these different categories of difference, it's a much broader sense of scientific and social scientific evidence that figures into these differences. So, for instance, if we look at the point about susceptibility to negative influences and outside pressure, they mention this ability or this lack of an ability to extricate yourself from a criminogenic environment at a younger age, right? So that's something that's based on, your inability to leave a community or leave a household, rather than something that's strictly about neuroscience. But when you get to Munchke, it's at least in the way that they specifically reference it in the ruling, they say it's about what neuroscience says about these three categories of difference, not differences in terms of your legal ability to leave your family home or extricate yourself from an environment, right? So very interesting there. We can talk more about that. But the important thing to also announce about Munchke is that even though it was a ruling from the Supreme Court of Washington, it was only a plurality opinion. The court was pretty divided, and by plurality, we mean that there were four dissents. One agreed in concurrence, but not in the reasoning, and so it was a pretty divided opinion. And I think this one dissent illustrates the kind of hesitancy to adopt this sort of shifting, ruling in light of neuroscience, where they say, well, if we just moved it up to this age, and neuroscience continuously is updating and telling us that the brain develops until 25 at least. Where are we going to draw that line? And so that same year that the court ruled in Munchke, they also made a significant development in the case of State v. Hogg. And so this case is a bit different because this is about life without parole, not mandatory life without parole. And it builds on a case a couple years before called State v. Bassett, which found that life without parole was unconstitutional for any juvenile, based on the Constitution in Washington State. And so, based on this, Hogg ruled that he had a 46-year minimum term given to him as a 17-year-old, and that this should also be deemed unconstitutional because it was a de facto life sentence. In other words, it was in effect a life sentence, even though it wasn't by name a life sentence. And so, if we look at this case, we see that the forensic evaluation and all the things kind of brought into the picture showed that there were significant hardships that should have been mitigating factors, and that there was significant growth and maturity since he received this initial sentence. They even had two forensic expert witnesses that really bolstered this point. But the court actually maintained his initial 46 year minimum sentence because they focused heavily on retributive factors. And so these, for example, were things like victim statements that are more about punishment rather than mitigating factors. And because of this, the Supreme Court of Washington argued that the resentencing court demonstrated abuse of discretion, and that they didn't sufficiently even rebut against the arguments or the points brought up by the forensic testimony. And in doing so, we're not actually following what these Miller-Fix statutes required a resentencing hearing to do, which is to look primarily at mitigating factors. And so, yeah, they also made very clear that de facto life sentences were similarly unconstitutional because, as they say, it leaves the incarcerated individual without a meaningful life outside of prison. And so, building off of Hogg, we find ourselves with the case of State v. Anderson. And this was a case that looked on paper pretty analogous to the case of Hogg, where this was someone with a 61-year sentence committed at the age of 17, and argued that these were similarly unconstitutional de facto life sentences. In this case, however, the Washington Supreme Court rejected the argument and, in fact, narrowed the holding of Hogg in a pretty significant way. What they said was that you should actually be reading Hogg not to ban de facto life without paroles for all people under 18, but only for those whose juvenile offenses, so the crime itself, reflect youthful immaturity, impetuosity, or failure to appreciate risks and consequences. So this is a pretty big shift, right? If we think about it from going from a difference of banning it altogether versus only for those crimes that themselves indicate ideas of youthfulness or immaturity, right? And so in this case, they looked to a few different pieces of evidence to say that at the time of the offense, the crime was not something that indicated these youthful mitigating qualities. And we can talk a bit more even about what those were, and those are up for debate. So, for instance, the fact that he was living alone on the streets was something that was considered as evidence of maturity, when from a neurobiological perspective or various perspectives, you might be able to say that that can actually be something that would suggest that the brain was maybe in a more youthful state if development was stunted in important ways, or if actions were having to be made under a more constrained and stressed environment, right? And then, yeah, they say that this did not exhibit the mitigating qualities of youth as a result. And I think it's really helpful to also look at the dissent in State v. Anderson to understand how divisive and kind of contentious these decisions are. If you look at Judge Yu's dissent in particular, she makes very clear that her reading of it is that the court was attempting to actually backtrack from their past ruling and was being either dishonest or mistaken to suggest that Hogg was about only those crimes itself rather than youthfulness as such. And so I'm highlighting this to say, following these pretty significant advances in what we might call developmentally informed justice, you see some sort of backtracking or hesitancy to adopt these in a full-throated way. And so that takes us to the case of State v. Carter. I was combining both the person Carter and also Righty in 2024. And so this was a case where individuals pursuant to Munchke appealed their mandatory life without parole sentences for murders committed at 18 and 20. And both these individuals had demonstrated significant rehabilitation since serving time in prison, and they were both resentenced to 280 months. This is a really notable case here because the Supreme Court of Washington, in a majority opinion, embraced Munchke, adding some weight to it, but also in a pretty significant way, I think, indicated that the kind of ruling in Anderson wasn't going to chip away at Munchke in the way that one could worry it might happen. And so in this case, they looked at their resentencing decision and found that youthfulness was a contributing factor only for one of the individuals, for Carter. But for Righty, in fact, they found that the crime itself, which was something related to a kind of long-term financial crime, did not demonstrate youthfulness. But what's really important here is that nonetheless, the resentencing court still found that a positive sort of departure from the initial sentence was reasonable because of the evidence of rehabilitation. And what's really, really notable going on here is that the court stands by this argument that rehabilitation itself is an indication that there was youthfulness at the time of a crime, even if that crime itself was something that doesn't demonstrate impetuosity. And so the logic here is, I think, pretty interesting to follow, where they basically suggest that if one is able to grow since committing a crime at a young age and recognize fault and mature since then, that indicates that at the time of their crime, they were less mature, and the fact that they did change indicates that the brain has, changed significantly in a way that's consistent with what we know about the developing brain. And so this case was then affirmed in a more recent case in 2025, and I think is a good indicator of where the court is currently standing. Yeah, and so I think this is a favorable reading that you can say that even if impetuosity doesn't show, you can have a favorable resentencing pursuant to Monchke for emerging adults. And I will stop there.
Okay, thank you, Andrew. So now we are going to turn it over to Nate Benjamin. We are so lucky to have him here. So Nate, I'm gonna just spotlight you and take it away.
I want to thank you for having me. I'm going to speak a little bit about trauma and how it all began for me, and I guess how it's relevant to the brain science. Basically growing up, I faced every single aspect of violence, being physical, sexual, emotional, verbal, every type of abuse you can think of. To me, I look at it as like a ketchup stain on a white T-shirt, and it was just hard. And I can remember, really just being hyper vigilant. Domestic violence, not really, understanding too much of what was going on. And then as I think the first really traumatic situation that happened to me happened when I was molested by a female relative, and I think that disturbed me immensely. And then when I was molested, by a male stranger, it had me confused and it had me very untrusting. Um, and it actually disturbed me for a great number of years. In fact, I didn't have courage to talk about it until I was like in my late 20s. But as things continue to progress, um, I remember as a kid, I really didn't have much good nights of sleep. I was always fidgety, and I was very always untrusting of people. Um, and then when my father died, this was like around the time when the crack cocaine epidemic was really blooming. And I remember that this was a time when my mother began to abuse cocaine. And basically, we didn't have basically anything. I started to venture out in the streets and, just picture an 8, 9-year-old kid. You coming from a place of, wanting to play with He-Man toys and G.I. Joes and um, into Michael Jackson to now, trying to figure out how, myself, how could I feed, my little brothers because my mother was an addict. And so here I'm in the street and now I'm seeing more traumatizing things. Seeing people shot, stabbed, seeing people engaging in prostitution, things of that nature. And so this it began to stain me in a way. But I think after that, as I got older, um, you know, being in situations where friends dying, but also being a victim of more violent crimes. And as we all know, have heard about alternatives to violence and restorative justice. Hurt people. And during that time, um, I experienced something at 17 years old, in which me and an individual we had words over a drug debt that he had owed me, um, regretfully so. And he he said he was going to come back, and he came back and he threw battery acid on me. And I can just remember, my clothes disintegrating. I couldn't breathe. Um, and I think after that time in my life, I was, it was just the iceberg, the tip of the iceberg, so to speak. And then I remember struggling while I was in the hospital and experiencing these night terrors even more and more. And I had already had these night terrors as a kid, but I didn't really understand. And so now, after I get out of the hospital, um, and I'm still having these night terrors and such, and urinating on myself, things of that nature. And now I'm 18, 17, and I come from an era where, I don't want to tell anybody what's going on with me. It's rather embarrassing. But this is what was going on, and um, I went back into the neighborhood and basically did what I thought what was best, which is wrong. Started, selling drugs again. And, without getting too much into it for, respect of, family and stuff. Me and another individual, we had words the night before a gun was pulled on me, and a threat was ensued, and I, thought that threat was serious, and I ended up taking his life regretfully and sadly, and it still pains me to admit that today. Um, I went on the run. And during this whole time after I got out of the hospital, I was self-medicating myself. with an enormous amount of alcohol and marijuana. Um, and, I thought, I could handle it, but obviously I couldn't, I ended up turning myself into the authorities, and they gave me a natural life sentence. And when I was in prison, they told me that I had PTSD. And I was like, at first, I was like, PTDD, because I couldn't even pronounce it, because I was woefully immature. And they said, no, PTSD. And they said it happens with people that were in the war. And I was like, I'm not Rambo. What is that? I've never been in a war. And they was like, no, but it also happens to people who went through an enormous amount of traumatic situations in their life. And so that's when, I started to begin to understand about PTSD and trauma and how it relates to me, and eventually how I understand to this day how it relates to, neuroscience, brain science. Um, but when I first came in prison, I was very aggressive, um, as I was before I came into prison. Always, physical altercations all the time, um, suicidal allegations, all of these things. And I was continuously dealing with severe post-traumatic stress disorder. And I wasn't getting any help, no mental health help. And this would go on for a great number of years. Eventually, though, I ended up going to MCI Norfolk. And when I was there, um, I began to really, take programs and education serious. However, I also wanted to still get my mental health right. And I met a beautiful clinician by the name of Mark Burrows, who I built an enormous amount of trust and admiration for. And at first, it didn't happen overnight. I didn't even like him. And this is when I started to peel the layers of the onion, so to speak, and work on my mental health and talk about my trauma. Eventually, I ended up going to another prison, in Old Colony, and I heard about EMDR. And I began to work on EMDR with another beautiful clinician, Vanessa Martino Fleming. And so um, during this time, I had heard about the Mattis decision. And I can just remember the day when I heard about it. Everybody was waiting. And I remember I was walking back from my prison issue job. And as I was walking down the ramp, this brother came and started hugging me, tremendously, and my 280-pound body with force. And I seen tear in his eyes. And as soon as I saw the tear in his eyes, I knew, and I went and I called my attorney and at the time, and I called my friend Michael Walsh, and they told me that Mattis' decision was rendered, and I have that opportunity to see parole. And during that time, I remember I went up to my cell and I put the sheet over my cell door, and I got on my knees, and I started crying. Because I never thought I would ever have the opportunity to be out here today, to be in the confines with my beautiful attorney and my mentor and my friend, to hug my family again and some of my friends, and it was just surreal. Brain science, the neuroscience. I'm just so blessed and thankful of the many attorneys, and the judges who had. Uh, the tenacity, and the courage, to really push forth within the court, to win this. I think almost all of the 200 guys, I know mostly all of them, especially from being in prison for 30 years and 5 months. And then talking to all of them and knowing their stories, almost everyone has went through something in relation to me, whether it may be sexually assaulted as a kid, victim of violent crime, shot, stabbed like me, parents on drugs and alcohol, coming from a dysfunctional family, um, and not even just that, but just people that I grew up with in my whole neighborhood. There have been some success stories. One of my good friends, I consider one of my sisters. You know, she even went through some terrible things in her life, but she's very successful. But you know, as I said earlier, and as I learned in restorative justice, it's her people, and you know, I understand the decisions that are being made, and sometimes it's difficult for the victims' families as well. And my heart goes out to them. It really, really does. Um, you know, but you know, where did how can we sentence an individual that's under 21 years, 21 years old, when the science states that the brain in some cases doesn't fully develop until you're 27 years old. In fact, you know, I say all the time when I'm speaking to young men or when I'm speaking to people in general, I didn't even know who I was as a person until I was like 27, 28 years old. And in fact, now just being out of prison, I'm beginning to know me more. I'm beginning to understand me more, and I think that it's a forever process. Um, but I'm just so immensely blessed and happy to have another opportunity through this decision. Um, and so I'm just looking forward to just being a spoke in the will, as I always say, and dedicating my life to just help others. And I just hope that we can continuously spread that germ. And when I mean spread that germ, man, we, you know, give that cough drop with that tissue and spread that germ and let the public know that we do have some redeemed men and women behind these walls that fall under the Mattis. Um, and hopefully we can continuously elevate because science continues to elevate. Science continues to push forth, not just in neuroscience, but science, period. That we can just do, we can continue to illuminate individuals that are incarcerated. And you know, I've read many times. Obviously, I'm not a lawyer. I'm not a psychologist or neuroscientist. I'm nothing like these beautiful people that's on board or that's listening today. But what I do know is that a great deal of individuals who are incarcerated, like myself, who have come out, it's very low that they reoffend. And so, you know, I'm just humbled and I'm just so thankful. Um, and so with that, I just wanted to say thank you so much. And let's really continue to just put our minds forward, our hearts forward, into just getting, you know, these stories out, not just the legal jargon, but these stories out that can just help other people, you know. And thank you and God bless.
Thank you, Nate. We really appreciate you being here, and that was really beautiful. And Andrew, if you want to hop back on, I'd love to turn to Q&A, so please feel free to put your questions in the Q&A. We already have some going. I'm going to selfishly start with my own. Nate, I'm curious how you felt when the Mattis decision came out. What was that experience like for you? What was that experience like for people who were inside, who were sentenced under Mattis previously?
For me, I was just very like emotional at first because, like I said, I would have given my right foot, literally my left hand, one of my eyeballs, whatever, to just have another opportunity to go home. And also, you know, my uncle, I love him to death, you know, and I wish he could be there. My mother, my friend Chambra, to see this, that I would just at least have that opportunity. And so I succumb with emotion, but happiness as well. But then I went to sadness again because, you know, I took a life. And regardless of the happiness and being free, I have, you know, I'm realizing that, listen, you know, I committed a crime and I hurt a family. And so it was a mixed amount of emotions. What I seen from being from behind the wall, I saw a lot of brothers. I'm pretty sure the sisters in Framingham were happy as well. But I saw a lot of men who are extremely happy, who are engaged. I think that some men weren't ready, but I think that most of the men that I were counted were ready. They've done the work even before this decision came down, as myself, because a man without a plan is a man who plans to fail. And I think that you never know what can happen. And so that's really what happened.
Yeah, and how has it been since you got out, and how do you feel like you're approaching life differently than you did when you were 20 and your prefrontal cortex was a little bit less developed? How did things feel different?
I'll tell you, like, honestly, like, if it wasn't for my lawyer, my cousin who I call my sister, some people from the church, some friends, um, some friends I know for years, I don't know where I would be. I have had a couple of breakdowns, meaning I remember the third day I was out, I went, to Walston Beach, and I just looked at the water and I cried, man. But it's a process. You're talking about some individuals like myself come home from 30, 40, sometimes 50 years. That's a long time, and I just hope that the public can have a little mercy and be a little gracious to us and understand that, we have changed, and understand, the circumference of the whole situation. But like I said, if it wasn't for, my lawyer and my sister, my cousin, but my sister and my family, my friends, and the people in the religious sector, I wouldn't know where I would be. I still struggle sometimes, being alone. Sometimes I want to be alone. Sometimes I don't. Sometimes, I have all these emotions that I never felt before. Like going to the store, like even going to the T, I don't even know how to get a Charlie card, or I'm still figuring out how to use the phone. And also, being involved with My Turn, Hillary Bender through Tufts University, and just some friends who I've known for years. Like Saturday, a friend that I grew up with, man, she took me out and just talked, and so that's what's been going on with me. Thank you so much.
Yeah. Yeah, and you're actually getting a lot of questions. I'm gonna keep going, not to put you on the spot. What programs do you think were beneficial when you were inside, if any? And what do you think sort of was responsible for sort of like changing your thinking or helping you cope with the trauma, the horrific trauma that you experienced as a kid?
Well, I think that first and foremost, and that's a good question. I think that Mark Burrows and Vanessa Martino Fleming conditions. I think the programs that helped me was Second Thoughts. At one time, I was the director of training. Um, Second Thoughts is where we're able to talk to at-risk youth who are incarcerated when DYS youth were allowed to come in. Project Youth, Boston University, and also they were in, actually, my family, my cousin, my sister, um, she's been my backbone, and some friends and family, and also some men behind the wall, some, individuals, Thomas Kuntz, Sean Ellis, um, Fuquan. Um, there's so many brothers and sisters behind the wall that have helped me immensely. Um, I just can't even begin to say, just so many people, some men that they're never gonna come home.
Yeah.
Zulu, so on and so forth.
Okay. And, I think this might also be a good time to nod to legal representation. So I know your attorney, Lisa Newman Polk, she's
I love
fabulous.
them. I
And, some attorneys, it's the parole hearing, they say goodbye, they, let you know what the decision is, and they're sort of out of your life. Like what role do you think having an attorney who sort of cares about you as a human and has continued to support you has played in being able to come home and transition?
Well, first and foremost, man, besides Dennis Toomey, I never, I love Dennis Toomey. Shout out to Dennis Toomey, but I never in my whole life dealing with the judicial system ever had a lawyer like Lisa Newman Pope. And I'm not just saying it just to blow smoke, man. She's just an incredible human being. It doesn't matter who you are, where you are. She's just a dedicated person. And so, just having her in my corner it's just I'm just blessed. To me, she's my Johnny Cochran, but she's more than my Johnny Cochran. Like she's just my mentor, man. And I call her sometimes when I need advice, and she always picks up the phone. And so I'm just blessed and thankful. And the parole board, they get a lot of flack sometimes, but they're just trying to do the right thing. They really are. They're just trying to do the right thing, And I'm just thankful and appreciative that they gave me a shot as well. I really am. And so that's what I have to say.
Thank you, Nate. I really appreciate that. There was one question about what role faith or religion played in your ability to get through your sentence and now sort of transitioning to being back at home. I'm curious if you could speak about that a little.
Yeah, so when I was younger, I was always in search, to find a relationship with the Creator, God. I never want to push religion or anything on anybody, but and so while I was in prison, I met a beautiful human being, and I heard he just got parole, Zachariah Ibrahim Bush, and he basically kind of just like catapulted me into just having that trust in a relationship with God. And at the time, I was dealing with the Islamic faith, and then also like helping me understand to have an open mind and an open heart. And then also, man, meeting Mike Walsh and Laura Walsh, beautiful people at South Shore Baptist Church in Hingham, beautiful people over there. And so, like, my faith has really helped me a lot. But it's not just my faith and my religion, but it's also my family, my sister, my cousin, my cousins, and my friends, they and my attorney. So it's that collective group, not just my faith, but all of those individuals, those entities that has helped me to just really keep it together. There's good days, there's bad days, but that's just where I'm at with that.
Yeah, thank you, Nate. Okay, one more question, then we're going to shift to some of the legal and forensic psychology questions. Then we'll give you a break, Nate. But there's one question about that sort of, so the question is, you said that you regret that you took a life, and what has helped you to come to terms with that? And was there a program that helped you, or like what did that look like in your journey?
Um, I think Mark Bros one time told me because I was seeking forgiveness and I wasn't getting it, and he said that you need to forgive yourself first. And so what I did was I just forgave myself. And once I forgave myself truthfully, then I was able to seek forgiveness, and anyone who has hurt or harmed me, I was able to forgive them. And so I think, working with Mark Burrows, and just like, just really working. Sometimes people don't like to talk about it, but mental health is real. And I think working with mental health and just really trying to connect with people, who care about me, who care about me, but also who won't lie to me, who won't be just a yes person, like the other day, my sister, she had to get on me, and then, my lawyer, excuse me, Lisa, my lawyer had to get on me, even, yes, last night, my aunt had to get on me, and so that's where it's at, you know.
Okay, thank you. So we have some other questions. There's a question about how to apply this research in evaluations or in testimony in cases where maybe the individual is now in their 30s or 40s, but they're being charged for an offense that occurred in adolescence. And the question is about transfer. So that I think is that's a difficult question because some of the transfer statute addresses where people are at in their current level of functioning. So it's not asking like, are they, at age 18 functioning or 17 age functioning right now? So I think that's a tough one. But what I would say for mitigation is that all of the research that we talked about applies. So I think that's a difficult scenario. There's a question about experts to use in Massachusetts for these kinds of cases. Feel free to send me an email. There's a very interesting question about it's hard to synthesize this one, but I think at the crux of it is whether the neuroscience is it's whether it's more neuroscience or whether it's how people are reacting at various stages in their life to different situations. And I think what I would say to that is that the science doesn't replace psychological or sociological factors. It sort of clarifies them. And while neuroscience can show us these like really predictable age-related differences and things like judgment, impulse control, capacity for change, this is also sort of grounded within the science of brain development. And the neuroscience sort of just like clarifies the psychological and sociological research. So thank you for that question. Let me see what else we have. Okay, there's a question about what motivated Andrew and me to do this work. Andrew, do you want to answer
Sure,
that one?
I can briefly talk about it. Interestingly, I came to this aspect of the work originally through my interest in the intersection of addiction and law. And the cases that really got me interested in law itself actually were about getting access to treatment for people who had substance use disorders in prisons and jails. And as I looked in those cases, I saw that neuroscience was this really important way to get judges on board with the idea that addiction is something that changes the brain in meaningful ways and requires medications for treatment often. And so that kind of led me down to explore other ways that brain science can dispel long-standing practices that might actually not be aligned with what the science knows is a more just approach. And so, yeah, I would say that led me into this whole space where, in many ways, I think you can read these cases that we talked about as attempting to just make the legal system more just by reference to what the science says is true about people.
Yeah, and I echo Andrew's response. There's a really good question about whether there are judicial systems that are outside of the United States that are reconsidering this sort of bright line 18 age cutoff or 21-year-old cutoff based on the science as well. And if there's anything we can learn from these attempts. So I embarrassingly have no idea. I think what I will say is that in a lot of countries, they don't have life without parole sentences. So everyone is parole eligible. And, in a number of other countries, there's a right to hope, there's a right to human dignity. We don't have that in the United States. So I would be interested if anyone wants to put in the Q&A their knowledge, or Andrew, do you want to add anything there? I don't know if you know about international contexts.
I'll continue to look into it, but similarly, need to as well.
Yeah, yeah. Um, okay, we have another question for Nate. Sorry, Nate, I told you were off the hot seat. Now you're back. Can you say a little bit about, and then I think you're going to have to unmute yourself, how you got involved in mental health counseling in prison? I know I've had a lot of clients who've really struggled to access mental health counseling. And so how did you decide to do that? And any thought about, whether other people who are incarcerated should pursue mental health counseling?
Well, first and foremost, I was blessed and lucky to have a mental health clinician for like 10 years. It's very unusual that that happens, but it just happened that way. Um, I think mental health, especially when you're incarcerated, is very important because I forgot the statistics, but they say that most of the incarcerated are suffering from some sort of mental illness or defect. And so, like as I was growing and maturing, I understood that the things that I went through and the things that I saw as a kid and coming up into adolescence wasn't right. And I knew something wasn't right in my body. A lot of times men in prison, they want to focus on, getting those broad shoulders and those big chests and biceps but I learned a long time ago from some good men in prison, getting your mental health right is right. I came in, man, um, and like I said, at one time I was ashamed to talk about it, but I was suicidal and all of the above, and I was hurt. I was broken down. Um, but something inside me wanted and yearned for more. And I remember I made a promise to myself after one time where, it was a situation where, I saw my son and I was in segregation, for physical assault on somebody. And I asked the officer, could you please not, cuff me in front of my son because he thinks I'm in school. And he said no. And then my son saw that and it made me feel so bad and broke down. And I made a promise that I was going to do everything I could because I survived. I tried to kill myself that night. And I made a promise to myself that I was going to do everything I can to change. But see, I didn't know how to change. I didn't know how to change or how to start the change. But the thing that came to me was my mental health. And that's when I began that road. It's been a long road and there's still work to do. But I think that, working on your mental health, not even just in prison, but even when you come out of prison, is very imperative and important, especially in the world that we live today.
Yeah, I
Can
think
be
that's a
very
great place to, I think that's a great place to end. And I'm so glad that you're here, and I'm so glad that you were able to get treatment for mental health. And I just want to thank you again for being a part of this panel. Your presence here was extremely important. So I want to thank everyone for attending. A recorded copy of this webinar will be available live in approximately 2 weeks. And you can feel free to reach out to any of us if you have any additional questions. Thank you.